I know that Senator Strickland cannot join us this afternoon.
Okay, thanks for that heads up. And, so start the meetings with the welcomes anyway. Welcome, everyone. Thank you for being here. I think everybody's used to that. Not that I don't want to exchange pleasantries, but maybe we'll just dive right into the meat and potatoes on this Friday afternoon. Latana, do you want to go over the rules just so we can check that box for us?
Sure, I'll do that real quick. Hope I'm not, okay. Good afternoon, everyone. I'm Latana Lawrence, and I'm the program coordinator for the Georgia Child Support Commission. I will briefly discuss a few rules to help us navigate the meeting today via Zoom webinar. The Statute Review Subcommittee members and staff are designed as panelists within Zoom and can speak at any time during this meeting. All other participants are designated as attendees and are muted during the meeting, but may type a message in the Zoom chat feature if needed. The Child Support Commission does not hear public comment during any of its subcommittee meetings. Accordingly, we will not be accepting public comments today. However, you may leave a written request for the commission at any time through the commission's website. For your convenience, I will put that web address in the Zoom chat momentarily. Also, anyone wishing to give public comment by speaking may do so at any full Child Support Commission meeting, the next one, which will be held on August 11th, 2023. And that is, oh, sorry, I'm a little lost right now. And the next meeting will also be posted in advance of that meeting on the commission's website. Once again, thank you. And I'll turn it back over to Katie.
Right. Yeah, thank you, Latana. I appreciate that. So as everybody hopefully remembers from our last meeting, where Judge Palmer ended up having a conflict, but we've got Dr. Benor with us from the Center for Policy Research, and we ended up spending our time with her at our last meeting, really focused on parenting time because Judge Palmer couldn't be here with us. I think the most efficient thing to do would be to go ahead and have Judge Palmer and the low income sort of issue as the leader of our low income issue sort of take over. We know that Judge Williford is going to be joining us a little later. But I just got a message. Thank you, Noelle. But we are at quorum. So while we have that, even though I do know that Judge Williford is going to join us later, so maybe we'll be above quorum, let's go ahead and address the minutes from the April 21st meeting. The minutes have circulated. The draft minutes have been distributed to the members for review. Do we have any edits or suggested revisions? Okay, hearing none, I would like to move to approve the minutes. If you are a voting member of the subcommittee, will you, raise your hand? You can physically, or you can do the little emoji hand raise to approve the April 21st, 23 minutes. And if staff will just let us know when that vote's complete.
Good, we're good.
Okay, great. Thanks, everybody. Appreciate you letting us handle that housekeeping issue. So I will circle back. As I was saying, we've got Dr. Benor here with us from the Center for Policy Research. We spent most of the time with her last time talking about parenting time. And I'd like to turn it over to Judge Palmer and Dr. Benor, where we will be starting our time with Dr. Benor at this meeting on the low income issues.
All right, Dr. Benor, I've reviewed your memo that's dated April 17th, and as I've said before, I mean, I have an opinion, but I do have some questions, some things I wanted to go over with you, and probably some of the other members do too. My first question I wanted to direct to Dr. Benor, it regards the self-support reserve, and you used Alabama as an example. I'm sure there are other states that do it, but do I understand that there's you calculate an amount that is a self-support reserve. And if the person's income is at or below that amount, then there's just there's what is referred to, as I understand it, as a $0 order, meaning they don't pay until they get over that amount. Is that correct? I mean,
Oh, Jane, you're muted.
I couldn't. I'm glad.
So sorry. For the record, this is Jane, Dr. Jane Venor. And regarding your question, so there's two policy decisions to be made.
All right.
If with the Alabama, it's the amount of the self-support reserve. And then in a lot of states tie that to the federal poverty level. And then the second decision, which is what Judge Palmer brought up, is what do you do when the income is below the self-support reserve? And that varies from state to state. Alabama has chosen to do a minimum order of $50.
Okay.
So with their, and you can do that. And then Arizona, which also uses the Alabama approach, they have no minimum order. They just, you leave it to judicial discretion, but in practice, they go with 0.
All right. So in Alabama, if you're at or below that amount, it's $50 period.
Correct.
All right.
They do have an exception in Alabama for incarcerated. They will do 0.
If you're in jail.
Yeah, or if you're disabled with no ability to earn.
The next thing I wanted to go over with you was and I'm just kind of going down through the North Carolina and South Carolina that had the table of income shares. Could you just, I think I understand it, but could you give me the nickel version summary of that approach and what you think of that?
Yeah, it's on page 7 and page 8 and there's 2 ways you can put it in the table. One is you just have one table, which is what North Carolina and South Carolina do. They incorporate it in the table. And then there's another option that we get into where there's a separate low income table, which is the way Utah and Wisconsin does it.
Right.
And the way that, obviously, there's efficiencies to doing it in one table, like North Carolina and South Carolina do it. But when you do it in one table, it also creates some confusion because if you look at page 7 of that memo, you'll see North Carolina's. And that shaded area has been adjusted for the self-support reserve. So somebody that doesn't have to do the math like they would in Alabama. Right. And what happens, in North Carolina is if you have 2 parents, and they have a pretty generous low self-support reserve. You'll notice that South Carolina doesn't, which is on the next page. Mm-hmm. But if you have somebody that makes $1,300, and if you read all that narrative in that exhibit 10, their order is going to be $50, which is the minimum order that North Carolina made a policy decision to do. And the way, if you read all that verbiage, if we had 2 parents making $1,300, we should use $2,600 as their combined income, which would be $497. And we would divide that by half, which would be about $248. And because it's in the shaded area, that verbiage says just use his $1,300 is the way that works. And that gets a little confusing. People don't like it. When you have a separate table, it's more clear when his income is low, use that. And then I just want to contrast that. If you look at South Carolina on page 8, they have a minimum order of $750. Mm-hmm. I mean, a minimum order of 100 at $750. Yeah. And then at $1,300, their order would be $265. So there's also a policy decision to be made even if you're going to put it in the shaded area and do like North Carolina, South Carolina, you have to decide how much their self support reserve is going to be. And in
So
North
I
Carolina,
noticed that they're at 1,300, their amount is higher than Georgia's.
yeah, South Carolina's
Right.
self support reserve is just a little under 800. And North Carolina's is over 1,100. So that's why you see the difference. So it's hard to look at it because you have to also think of what's the appropriate self-support reserve for Georgia. It's, really there's the mechanism, which is the shaded area. And then we have to talk about the parameters. How much is that self-support reserve and what's the appropriate minimum order if you were to go down that path?
Dr. Vidor, may I ask a question? And I apologize in advance if this is an ignorant question. I do not have anywhere near the background on this issue that Judge Palmer does, but how do these other states that we're talking about and that you're using as examples in the memo, how do they calculate their self-support reserves?
North Carolina elected to go with 100% of the federal poverty level. And South Carolina, they went with a poverty level from a previous guidelines review. I can't remember the year off the hand, but they're very sensitive about reducing those order amounts at low income. So they decided to retain their existing self-support reserve, which was based on a poverty level from, I want to say 2003 off the top of my head.
Does the self-support level for North Carolina automatically adjust when the federal poverty guidelines change?
Yeah. They only adjust it every 4 years. If you want to do something that automatically adjusts it every year, it's better to put it in the worksheet like Alabama, because otherwise you have to have somebody like me come in and change those amounts in the shaded area. We're back down to less than 5% inflation, and hopefully that will remain. So historically, it hasn't been necessary to really update it annually until this recent inflation in the last 2 years.
All right. The next, category is the Wisconsin. I think you used Utah maybe, but it's the same idea. This is the one I like, and I've said several times that I like this because I think it's a simpler approach, and it has everybody. You're paying something or paying a percentage of whatever your income is, and I like that approach better. But I want to be sure I understand what the downsides of this are, and you talked about that, and give you an opportunity to talk me out of it.
I am definitely let a state decide what's best for their
I know,
state.
but that's we're paying you to give us your opinion, and that's what I want you to do.
So on page 13 is a draft of the first stab at what a low income table for Georgia would look like.
Okay.
And I made lots of assumptions, and it really is the prerogative of this commission and Georgia to decide what those assumptions are.
Uh-huh.
And those assumptions are below 800, and this was just kind of arbitrary. This produces a zero order if the payer parent has zero income. And I arbitrarily set 800. That's pretty close to what the SSI benefit is, supplemental
Right.
security income. And I used 20 to 28% at that level. And the reason I used a percentage, and again, this is all policy decisions. So, I put this out here so you can edit and come up with something appropriate for Georgia.
Okay.
I use a percentage just because of the Federal Office of Child Support has come down on Louisiana for its minimum order of $100. They received a letter about it. And as you know, it goes into the state plan. Deborah, do you want to ask a question? Do you want me to pause?
I think it's good to continue providing your answer to Judge Palmer. The question I was going to ask is, which of these various systems take into account the other parent's income and whether or not they're also below the poverty level or whatever the self-support reserve is set at? Or are all of them just looking at the payor parent's income and not paying attention to the other parent's income? So that was my
Sure.
question, but
Yeah, let's put that in the parking lot right now, and we'll go through this exhibit 13 on page 13, the example. So you all know the assumptions that I'm making and what you can modify, where the policy decisions are. For below 800, I use a percentage because obviously if there's zero income, you're going to have a zero order. And I don't want Georgia to end up like Louisiana with a letter. We don't know
Thank
the
you.
reason specifically. Louisiana couldn't share all of the letter. They gave me parts of it, but earlier in the memo, there's the feds say that orders are supposed to be based on ability to pay. And that's what they said in the Louisiana letter. And somebody that has that, the evidence says that their income is zero, has no ability to pay. So obviously at their 20% of zero is zero. So that's the way we do that. But you could change that 800 and make it something else. I use 20 to 28% because there's a study quoted in the federal rulemaking, the narrative that says that orders go unpaid if they are below 20% of gross income, and they repeat it, even though there's also evidence now that disputes that they say that income imputation matters more and default matters more. That same study says, which was misquoted in the federal rule, actually says it's up to 28% for those that have more children. So that's the reason I start that first line at 20% for one child to be consistent with that study, which has mixed evidence. And then I bring it up to 28% for 6 children, which is consistent with that study. But again, there's mixed findings. So you could use another percentage. There's an argument for it just because we have new evidence. The reason I increase it is Georgia already right now with their minimum order increases it with the number of children. So I'm assuming that that's a perception that you want to continue. And other states, some states don't. They still have the 20%. I actually mathematically like an increase because it makes it easier to flow into the regular schedule amounts. So then above 800, I just did a simple thing where I increase it, at 1,500, the dollar amounts are the same as existing Georgia income shares table. That was arbitrary. So that's above minimum wage, which would be 1,257 a month.
But if we adopted this, then 1,500 would be the cutoff to go back to the regular.
Right. And
Right.
you could come back to me and say, Dr. Vinar, we don't like it at 1,500. We want it at 1,300, or we want it at 2,000.
Whatever. Right. Okay.
And I'll say, okay, I'll do it. And if you wanted to change those percentages, I'd do it too,
Right.
And so then all I did was just increase it so it's consistent. Like if you calculate it, you're going to notice that it's roughly a $13 increase, $12 to $13 increase per income interval for one child. And so that's all I did, nothing fancy. And I would say the drawback of this approach is that, well, let me backtrack. One reason I would like to see it be less than $50 increase because of payroll taxes, because, with a parent got a raise, we don't want all of it to go to child support because we want to respect that he also has to pay increased FICA and payroll taxes. So we can change that. And then I would say the weakness with this approach is that you have a separate table. Sometimes people think that's cumbersome. It was now not difficult to program, so that's a non-issue. The second thing that's a little bit of a weakness is that it doesn't have a clear self-support reserve. The federal regulation says have a low income adjustment such as a self-support reserve. It doesn't necessarily say you have to have a self-support reserve. So that's good. And then back to that other question is that it doesn't deal with the CP or the primary parent's income. And the only way that we could deal with that is in the worksheet, if you go with the Alabama approach. And to be honest, I wouldn't even recommend it. The two states that do it are Arizona and New Jersey. And what they do is they say if the obligee's income is below a certain level in poverty in New Jersey, that we don't give the low income adjustment in New Jersey to the obligor. And that really doesn't make sense that the money is, let's say the receiving parent is receiving TANF, that money would get distributed to the state. So, but I do highly recommend that you do have a deviation factor at least for situations so you can deviate so that low income adjustment isn't always applied presumptively. Alabama really debated that issue, and the feeling, and this is consistent with the narrative in the federal rules, is that it's better to get consistent payments to the CP than to try to assess a higher order and get no payments.
All right. Well, I like what you did there. I mean, that's exactly what I was sort of looking for. And one thing is my understanding, based on what you just said, it sounds like the problem in Louisiana was that they were, if nothing else, imposing an obligation on people that actually had zero income. Is that right?
I don't have firsthand information. They only gave me partial information, and the 4D director in Louisiana, she didn't really understand it either, what the feds were getting at, but that's what we surmised.
Well, I mean, we can't do anything about that, but all right. Well, I like what you did. As I've said before, I don't love the concept of a self-support reserve because I feel like, a percentage approach is better as a policy matter to me, because if your income's $100, you ought to pay some percentage of that to support your children. I don't think there ought to be some amount, that is protected. And in the past, I've compared it to, and I know it's not a perfect analogy, but I've compared it to an exemption in bankruptcy or a homestead exemption or something like that. I just don't think that kind of concept ought to apply when we're talking about child support. And that's why I've been in favor of this. And I like what you did. But I want to, I don't spend all my time looking at this stuff, as you might imagine. So I want to hear what everybody else thinks, and, give them an opportunity to ask Dr. Vannour questions. I've talked to some of the other members of the subcommittee. I talked to Judge Williford the other day for a while. So does anybody else have anything they want to bring up about this or questions for Dr. Vannour?
Well, I'm sorry I came in late because I've been on the bench, and so I may have missed some of this already, but I guess Judge Palmer, what you and I were talking about was, with the self-support reserve, I guess the idea is that you need so much money to pay your bills and survive before we tap into any of your money for child support, but wouldn't that apply to everybody? I mean, we all need a certain amount of money to survive before we have any money to tap into for anything else. And I've always been told, heard, and of the opinion that child support comes first, that you have to support your children and then you see what you have left to survive. And the self-support reserve seemed to be just the opposite of that. You support yourself and then you look at what's left to support your children.
I mean, that's my view too, Judge. I mean, and I know, and I think the way that something like the table Dr. Vanur, the proposed table she prepared for Georgia, kind of deals with that, in that you create this, you know, if you get into what we call, whatever we're going to call low income, whether it's $1,500 or some other number, you move into this table where we're being a little more forgiving, but we're still saying you have to pay this percentage of whatever your income is at almost all incomes. And I like that approach.
And there are other states that are doing it that way.
Yeah.
right?
Wisconsin was the one I looked at however many years ago it's been now that we did the other study group that we had. But Dr. Vanur used Utah, which was the same idea. And I think there was it Nevada maybe was the other state that, I think there are a few states that do that.
Okay.
And I can't think of a reason why this wouldn't, you know, pass muster with the federal. It sounds like the Louisiana issue was that they just had, you know, they didn't account for, maybe the problem was that the zero income imposed the same as, you know, significantly higher incomes, which I agree. If the number's really zero, then the table should show the award is zero. I also think, as somebody else said, I think Dr. Vanur said this, anything we do, I agree, we ought to maintain a non-specific deviation or some sort of discretionary tool for the judge. Because, you know, as we've said over and over again, I mean, no matter what table you come up with, you're always going to run into a situation that, you know, has some unusual fact pattern or something that, you know, you're going to need to deviate in a way that didn't call for in the table. But I like the table that she did, I guess, based on what I had said a couple months ago. And I appreciate that. Anybody else want to
I
ask
see we
Dr.
have two
Vanur
hands
anything?
up. Mara and Deborah, we have two hands up. Who's next?
Oh, okay.
I might jump in to follow up. This is Deborah Johnson. Although I am happily retired this year, for the last 40 years or whatever, I worked with low income people, both parents paying support and parents receiving support. And I've been on the low income deviation work group this round and some prior rounds. So if I understand correctly, it sounds like, from what you were saying, Dr. Vanur, that none of these approaches are taking into account the residential parent's income. It's just not part of the calculation. Is that correct? And so we're having simplicity by only looking at the non-residential parent's income, or if the residential parent's income is being considered, in what way is it considered?
Ostensibly, the Georgia, Arizona approach will consider the receiving parent's income. It's a line item on that worksheet, and I'm looking for the page number so you can see it. So ostensibly that line applies to both parents. The question I have for you is, what do you think is fair and appropriate for Georgia families when both parents are low income? And you can structure that, what you think is appropriate. You could probably mesh it with the low income table. Utah, Wisconsin, Nevada don't have anything other than a deviation criteria.
Mhm.
But if they're both low income, do you believe that the paying parent shouldn't get the adjustment?
I'm concerned about the idea of a self-support reserve applying to only one of the two families involved. And because the result is, as I see it, that the parent the children live with then is the sole support for the children. And it means when the children are in that home, they have a much lower standard of living than when they're with the other home. Now, mind you, they're both going to be low, but the one family is having to pay daycare, rent, utilities, all those things to support the children, and the other home is not, or not to the same degree. They're certainly, if the children are visiting regularly, there needs to be a place for them to visit, but it doesn't need to be necessarily as much of a place as we hope it might be for where the children usually are. And having represented poor people so long here in Georgia, my first 10 years of practice, I was in Michigan, and my later 30 whatever years, I've been in Georgia. So very different economies in the two states and very different welfare systems. Georgia's welfare is amazingly low. And in my experience, representing low income people, almost nobody was on TANF. People were getting, if they were getting public assistance, they got food stamps, they got Medicaid for the kids, usually not for the adult. And if they were really lucky and their name came up on the magic long list, they got a daycare subsidy. But pretty much nobody got TANF. And if they did get TANF, then their income had to be way below the poverty level, way below. The current TANF amount for a family of 3 is $280 a month, period. And that is the same number it was when I moved to Georgia in 1991. So the idea that somebody is making up the difference between their poverty level income and reasonable income for them to care for their children with TANF, that's not reality in Georgia. So I'm real concerned with the self-support reserve idea. And in my mind, it makes more sense to say, okay, if everybody's poor, then we figure that the amount they can contribute is low, but we don't figure it's zero. I'm uncomfortable with the self-support reserve means you don't have to pay anything, but I'm well aware that it is incredibly hard for people to pay child support when their income is at or below the federal poverty level. Legal aid's income limit for clients to qualify was actually above the federal poverty level. So I was representing people whose income was maybe 150% of the poverty level. But they're struggling. They're really struggling. But if only one of these families is having to pay for childcare, that completely alters the situation in the two families. And so to say that the parent the children don't live with doesn't need to contribute at all to the other household if their income is below a certain amount is troubling to me. But I realize it adds a lot of complications to try to figure out how can you have a simple system that's also figuring out some kind of a break for the parent that would be taking the money out of their pocket as opposed to pay the other parent, as opposed to the one who's taking it out of their pocket to pay the daycare provider or the landlord. For that reason, I really like the idea of figuring out a way to build it into the tables. Great, make it simpler, but something that says we only look at one household, not both households, troubles me. And so I think that's what I have to say.
May I clarify?
Please do.
I think that actually what I heard, and maybe I misunderstood, and I appreciate you bringing all your experience to Georgia, is that you and Judge Palmer are actually on the same page.
That's what I
And we've never ever talked to each other about it.
that I think that Judge Palmer is on the same page, that something should go to the family, you know, and I apologize that it looks like that, you know, it only considers the paying parent's gross income on that page 13. It really actually considers the needs of the children and what the children are going to get by saying 20%. I mean, that's pretty close to what it costs or what would be expended by the custodial parent too. So, well, according to the economic data, we're not talking about what you know.
Yes, yeah.
You know.
If I, please go ahead, and then I need to ask a clarifying question.
Yeah, so that I think is where you see that the custodial parents or the needs of the children are being not necessarily met. It's as much as can get 20% to 28% and have it paid, because you know it's one thing to set the order amount, it's another thing what that amount is going to be paid. So that line is trying to get at the maximum. So it does consider, it's respectful to the children, you know, in the sense that it's designed to get the maximum that the data is saying that those very, very low income parents will pay. What we don't want to do, and this again is just, I'm assuming Georgia doesn't do, what you want is 100% compliance at low income. You want to get as much as possible, but you also don't want to start doing driver's license suspension and all that stuff that a low income paying parent, unless he really does have the ability to pay, that he's going to put it, you know, it's going to put him in jail or take away his driver's license so he can't earn it. He's going to have to take off work to go deal with this driver's license suspension. His job's not the type that he has flex hours. And what we've created is even a worse situation for the children. So it's really finding that fine point. I'll stop there.
So am I understanding, and please forgive me, but I have not read your report, Dr. Vanor. If I had, then I might understand better. I'm going based purely on the presentation today and trying to follow it. And I'm very visual, so I'm at a disadvantage there. But it sounds almost like if we're at a certain income level, above a certain income level, then it's an income shares model. But below that income level, we're no longer income shares. We're going back to where we were back in the old days, where we were just looking at the paying parents' income and making our child support calculation based on that. Am I understanding correctly?
Yes and no. I mean,
Okay.
you probably want to have an exception, like if she's a millionaire, the receiving parent, you probably want to use income shares.
Yeah,
Why
sure.
would you, you know? So yeah, so it's much more nuanced.
So in a both families are low income situation, we're basically just doing the old fashioned way where it's a percentage of paying parents' income. And it makes it, that's how we're figuring in, rather than doing a self-support reserve, that's how we're, say, recognizing that the burden on the paying parent is going to be taken into account by just focusing on their income instead of focusing on both incomes and daycare and all that other kind of stuff.
Well, I don't think that's the absolute rule. If if they're both low income, yeah, it would be, this says a percentage, and the price, the reason you're going with that, assuming you would, is for simplicity. It keeps it very simple, but
Yeah.
there are, and she doesn't necessarily, or the receiving parent, I apologize for, using he or she. If the receiving parent, it doesn't even have to be a millionaire that they're receiving. There might be some situations where she's making, I don't know, maybe 60,000, maybe 100,000, where it would be still advantage to use the income shares approach.
Okay. Well, the simplicity issue is certainly important. I think that's the reason people who have been complaining about our current low income deviation is it's too complicated and people can't deal with it. So they just switch and do the non-specific deviation where they can think they can do whatever they want. So simplicity is important. I grant you that. And so is equity. So that's the tricky balance. Thank you very much.
And I see Carol Walker has her hand up as well. Carol. Unmute.
Well, Mara has had her hand up.
Yeah, she had her
Oh,
hand up.
sorry.
Yeah.
Okay. I apologize, Mara.
No, that's
The
fine.
hand icon.
I just wanted to say that I think that we need to be really careful about making sure that judges continue to have discretion, and I think avoiding that minimum order requirement, or at least giving judges discretion to go around it or not impose it in certain situations, because I think, as Dr. Vanor kind of touched on, like, we don't want to set people up to fail. That doesn't help kids. And then we get people in the spiral of being trapped by these child support orders and arrears that make it very difficult to climb out of and overcome eventually. And then I think people kind of shut down and don't want to engage with the system at all. And so, whether we use a self-support reserve or a table, just making sure to keep that discretion available so that attorneys or parties can make those arguments as to why, in certain situations, it's really like a zero child support order in limited, very specific fact patterns is and can be appropriate. And there needs to be some leeway for that.
Yeah, you don't need to worry about that, Morris. I think there are enough judges on the commission that pretty much all judges want to retain as much discretion as they can. I know I do, because I know that you're never going to come up with a table that deals with every fact pattern. Like some of the stuff that Deborah was talking about, maybe there's a higher daycare cost, or one parent has a much higher. I mean, there are just all kinds of weird things that maybe the child has some kind of special need that requires some kind of extra expense or something. I mean, there's just everything you can imagine and more comes up in these cases. So we definitely need to, I see this as more of a, sort of a default mechanism, that would come into play if either nobody exercises, the judge doesn't exercise that kind of discretion, either because nobody asked for it or for whatever reason. You would just have something that was a default table that took the low income issue into consideration. I think that's what we're doing. I in no way want to take away a judge's ability to deviate from this if that's appropriate.
Thank you, Judge Palmer. This is Elaine. I just want to point out our time factor. There may be some things that Dr. Venor needs to tell us today about low income deviation. And I know we have a couple of questions. Carol wants to provide some input, and Deborah again as well. And as valuable as that is, let's keep in mind that we only have a 2-hour meeting today, and we need to make sure that our second hour is devoted to parenting time. So do you want to, Jane, does that sound fair to you? Or there some things that you absolutely need to cover with us today?
Thank you, Elaine. I think this discussion is really good. And I think Judge Palmer is actually right on that. We would never recommend to take away the deviation factor, and the feds don't want that you should still have a deviation factor for the low income adjustment. The whole guidelines is a rebuttable presumptive. Right. And with regard to, we do think it is the best practice to specify when circumstances where you might want to do a zero order. There's some language that you can look at in Alabama, Illinois, and Arkansas, where if they're incarcerated, if they're physically disabled to the point where they can earn no income, if they're institutionalized, some of those situations, but that's something you could do outside of this call. I think the fact that we still have hands up, and I'd rather hear from them, because I think I don't hear anything yet that's telling me that that table is a bad thing for Georgia. So that's what I'm really listening for. Even what Deborah said was consistent with what Judge Palmer said. So that's what I'm really listening for.
Okay, good. I'm glad that you're comfortable that we're on the right track. Carol, do you want to make your comments now?
Well, I apologize for putting my hand up. I didn't really mean to, but I do have a hypothetical question. Let's assume we're going to do not have a self-support reserve, but the ability for a parent who has zero income to pay zero child support. At that time, if that parent also has significant parenting time with the children, could you end up in a situation, Dr. Venor, where a custodial parent would actually be paying support under an income shares model to a non-custodial parent?
I think that depends on how you structure your low income and your time sharing adjustment. And let's back up. I mean, I think that Georgia judges are pretty diligent. If there is zero income, I mean, this is based on where I sit, which is my ivory tower. It's zero income. There's not a potential for income. I mean, based on what I see, income will be imputed if there's ability to work.
That's right.
You know, so that situation would have to be, you know, maybe it's a paraplegic that has zero income and no ability to work. And, you know, and I feel I'm not sure if I'm being sensitive by using that example, but I mean, in that situation, why would you want to deny that parent time sharing if that parent is capable of it? And then it becomes your time sharing adjustment. Right now, no. In Georgia, you'd have to have a deviation. So I defer to Judge Palmer to speak on what he would do in that situation.
I can't imagine I would have the custodial parent paying the non-custodial parent. It's hard for me to think of a scenario where I would order that. I don't think I would. But you might very well have in some of the situations you talked about, like somebody that was totally and 100% disabled, never able to work. Maybe they just don't pay anything, but do have some kind of visitation or something. I mean, that might happen, but I can't think of a scenario where I would order the custodial to pay the non-custodial.
Yeah, and I don't mean to interrupt, so sorry, but I think that's where, you know, those are, you know, these are guidelines and they're rebuttable, presumptive, and it's a painful scenario to think about.
Yeah.
So I think I think we have to trust some judgment, and right
But
now.
that kind of thing, that kind of thing happens. I mean, I've had in real cases, but it's unusual. And it would also typically be something that, the judge is going to know about and would put more effort into thinking about how to deal with and deviate as appropriate or whatever. These are more the table, as I said before, is a default. They're guidelines. It's for the typical situation, not some weird, thing that happens once in a while.
Unfortunate thing that happens, yeah. I mean, we want both parents to be physically able and,
Well, sure.
yeah. But anyway, I'm sorry, I don't mean to interrupt.
No.
I mean, I saw Carol, did you want to follow up since that was your question?
I apologize.
lost-
I'm sitting in an automobile in a parking lot in Missouri. No, I had already muted myself. Thank you.
Thank you for the question. Thanks for being on the call. I don't know, it sounds like Elaine's our gatekeeper on time, so,
Just a little bit. So Deborah, you have your hand up again, or was that a
It
hand
is
raised?
up again, and it's just to say that I wanted to follow up on what Mara was saying about minimum orders. And I really, just like I don't like self-support reserve, I don't like minimum orders either. I think that's what percentages and,
Right.
judges are for. Having a minimum order, the typical person I've dealt with in the past who was unable to pay, if really had zero income, was somebody who had applied for Social Security and SSI and was waiting for the 2 years or whatever it's going to take for that decision to happen. And they either are or are not able to prove to the judge's satisfaction that they're truly disabled. But that's the typical situation that I've seen where somebody really can't pay. There's plenty of other people say they can't pay, but the ones I've seen that really are in this situation, it's usually waiting for the disability to be decided. But I really find the minimum order idea just doesn't work in real life. If somebody's on SSI, their income is way below the poverty level. And the guidelines already say that income doesn't count. So that means it's a zero order. And it should be a zero order because that person can't do any more than that. But anyway, that's all I needed to say. And I've taken more than my fair share, so I'll be quiet.
Deborah, may I
Elaine.
ask some?
Go, Elaine, do we need to vote on something about this or?
Not today, because I
Okay.
don't believe that we've actually concluded anything. We've not made
No.
any precise decisions. So I believe that Dr. Venor, we're going to need another hour on the next agenda to continue. We anticipated a couple of hours of discussion on just low income. So I anticipate we need to do that. We may need to regroup a little bit, staff with you and the co-chairs, and talk about, which would include Judge Palmer, talk about what we have discovered today and what we need to make sure we cover at the next meeting. Jane, does that sound appropriate to you? Okay. Okay, and I know we do have a few more minutes, so if there are other comments from the panelists or questions, anything you want to talk to Dr. Venor about, you have her ear. So now's that time. Are we bashful today?
Well, this is Chuck F. Stration. I just want to, I'm the new member here on the panel, so I have appreciated the discussion and I'm trying to get caught up on where things are, but it seems like the first stab at the table that was included in the memo, there's real consensus around support for that framework here today. And the importance of an amount to be paid, but also recognition that just a certain set amount may not be the best way to approach this, that a percentage may be better. And so I know that maybe a discussion needs to continue, and at the risk of speaking too early, as I'm a new member here, I would just say if there's I would support a decision of the subcommittee here today to empower Dr. Venor to work on updating the first stab just based upon the comments heard here today, so that we may have a subsequent proposal that we can act on at a future meeting. Thank you.
I agree with Chuck.
I like that idea too.
All right, that's what we're gonna do then. Dr. Venor, based on what you heard today, maybe take another look at it. If you think you can improve on it at all, add on it. And Elaine, can we shoot for the next meeting to take some action on this?
I believe if the members believe we have reached consensus, then that would be appropriate. If Dr. Venor feels like that we have, made a conclusion that will reached a conclusion that will work for Georgia.
We might want to have like another sidebar conversation, just so I can play with some of the parameters. I'm not sure.
Well, I think what we're saying is you talk to the staff and however you need to, and at the next meeting, you'll give us your next best shot at it. And then if nobody has any, we'll have some discussion, but we'll anticipate going ahead and taking some action and coming up voting on a recommendation to the commission. That's what I think Chuck was saying, and that's what I want to do.
Yeah, I think the only thing I haven't heard like is 800 or 1500, the right incomes, and that might be too much in the weeds for this group at 2 minutes before 3.
All right, so Jane, you're addressing like in our old low income deviation, if the income was at 1850 or less, it was low income. And if you were at 1851, it wasn't low income, which was, and I'll put on my hat of many years ago working with the commission, that was one of the reasons that they changed that bright line from 1850, was because if you were at 1851, you didn't get a low income deviation. And the commission was very troubled by that and wanted to change to where we are today with what we have today, where you have to determine that extreme economic hardship. But we're talking again about including that bright line test of income level, correct, Jane?
Yeah, so that helps. So yeah, we can have a sidebar with the staff on that issue because we don't want to go backwards. Thank you, Elaine, for that history.
Yeah. I mean, that's something that we need to think about, is where we are with that. If we want to, if we just simply go back to 1850 or less, we're walking back in time to where we were when the commission determined in 2008 that was really not working well for Georgia. There was a study committee then, and then September 1st of 2009 was where the statute changed to what we have today. So we want to be careful about that. I can remember Senator Harp, who was the chair at that time, talking about a gentleman who had come in his office. He was earning $2,500 a month, but he said, by the time I looked at everything as his lawyer, I felt like he's really low income, although he was above the 1850 or less. So the commission went down that path all those years ago. And I don't know if there are any members today who were here then in 2008. Deborah she was at those meetings, yes, as a non-commission member, but she remembers those days of all the discussions. In fact, it was the late Deborah Burns who chaired that subcommittee. Deborah will remember. And so there was a lot of effort made to move us away from that bright line test. So we need to think about that as well. I'm just putting that out there for thought.
And I will clarify really quickly is that this isn't a bright line test, that I structured it to be gradual, but we should have that. We definitely don't want to take Georgia backwards. So we will double check that.
Okay.
I do think, though, that the complications of figuring out under the current system what somebody's income really is, or what's available, et cetera. That's part of what everybody's complaining about, is too complicated. And as I recall, back in 2009, the consequences of either being above or below that line were a lot different than the consequences that you're proposing in this current thing. So I'm not feeling like bright line is necessarily backwards, even though that was part of what the old system was, just because what happened if you were below or above it was different than this.
Thank you, Deborah.
My friend Ryan.
Hey, Jane. I just wanted to throw, I mean, we're talked a lot about poverty today, but just to kind of throw out there and be cognizant of the fact that the 2020 census data did show that a large portion of the poverty population is single mothers. So this is something that drives these folks into poverty. So I don't want them kind of left behind and focus on the other side of this either. So that's all I had. Good to see you, Jane. And everybody else.
Thank you, Ryan. Judge Palmer, is there anything else from you?
No.
Okay, so do y'all feel comfortable moving on to parenting time now? To put it on a different hat?
All right, let's do.
Ready to go to parenting time, Judge Williford?
I am.
Okay.
For some reason, I was having some computer issues with my laptop, so forgive me. I've had to switch over to my iPhone. I'm glad we have so many different technologies at our disposal. So why don't we pick up where we left off at our last meeting and just dive back into the parenting time issue and how we need to deal with the parenting time issue. Just looking at, Elaine, remind me, somewhere you sent me a nice executive agenda where we
Yes, I
were going
did this morning.
yeah, where we were going to start today on the parenting time.
Well, now, Jane, you made some updates to your last report, addendums. And so we can, you might have a better sense of where we need to kick off the conversation today.
Yeah, what was the big request was to see the calculation for Minnesota. And there was a friendly reminder, the study group, how hard they worked, and their very thorough report that tend to, and I apologize, I'm not seeing the name of the person with the study group right off the screen here because I want to call on them, but there were some little, favoring sounds like too strong of a word toward Minnesota. So the memo, if you go, it's difficult to look at the page numbers. It's about 6 pages from the end, 1, 2, 3, 4, 5, 6, and it's addendum. It's called addendum page 1. And it steps out the Minnesota formula so you can see it. And the sentiment during the last meeting was that I had an example of the cross credit and I had stepped that out, and people said that was very helpful and they wanted to see the same thing for the Minnesota formula. With that said, I developed a worksheet. I'm going to call it a worksheet because that's my vernacular. I don't think that's what I think you would call it, a schedule in Georgia. But I will say that it's a black box in the states that use this formula. You know, if you look at that formula on that page 1 of the addendum, just toward the end, you'll see that there's A0 to the to the second power. So, you know, you don't do that math in your head where AO is the number of overnights, approximate number of nights with the children with parent A. So both Minnesota and Michigan just calculate it, and they don't have all these steps in a worksheet. And if you look at the rest of that memo, you'll see that they have, if you look on page 3 of it, you just see that, like I pulled Minnesota's, I think that's from Minnesota. Yeah, you see that line 6A where they just show the adjustment. They don't show you all the steps in the calculation. But the reason that the study group was interested in this approach was because there was a cliff effect. That is that you get to a certain time sharing threshold and then all of a sudden, oh, wow, you get an adjustment. So that order amount plummets. And when you go to these more complicated math formulas that use exponentials, or Oregon, where they have an even more complicated formula, but they reduced it to a lookout table that's essentially every night. If you have 1 overnight, you get 0.001 adjustment, 2 overnights, you get 0.0012, is the way that you combat that to avoid the cliff effect is you make a more complicated formula. And you also start that time sharing adjustment at a lower threshold. And so there's a trade-off between keeping it simple and avoiding that cliff effect. I will say that we are working with Colorado right now, and I'll say this really briefly because I'm sure I tired people out with what I've said so far. Is Colorado does a very intuitive approach. It's the approach that's used in Florida, South Carolina, North Carolina, most of the states, Alabama that surround Georgia, where it's like you calculate an order for mom, you calculate an order for dad, you weigh it by the amount of time with the other parent. So that's what the other parent owes, and then you offset it. And when they calculate those theoretical orders for each parent, they increase it by 50%, 150% to account for both parents having housing expenses. And that formula tends to have a cliff effect when you get to a time sharing threshold. What Colorado is deciding to do is to take away that threshold. Like in Alabama, they use a threshold of 50% equal custody before that formula applies. Colorado uses a formula of 93 overnights before that formula applies. What they're saying is that we're going to apply it to any situation, but if it results more than sole custody, we're going to go with a sole custody order. And that will happen when the paying parent's income is very much higher than the receiving parent. And so with that, and the reason that happens is because we said that it costs more to raise a child in 2 households than 1. So that's why we do the 50% increase. So I'm going to stop there because I'm sure I confused people, but the main thing is the supplement asked for a step out of the formula for Minnesota, and that's what the addendum does.
Well, what do you think about that? What Colorado is doing for Georgia?
I actually like it. I like it because it's intuitive that you do a theoretical order for each parent. You know, but I also respect that the study group really liked the Minnesota formula, and the Minnesota formula works well too.
I'm going to comment on, not necessarily on behalf of the study group, but I will say that as a member of the study group and trying, and I guess, I mean, I chaired it, but I tried to, you know, aside from running the meetings, be just a member. I think the appeal of Minnesota was, at least for me, in large part that that they seem to have already made some of the mistakes and fixed them. more so than just that their method was, so perfect it belonged on a pedestal. It was more that, as we interviewed and had guest speakers from different states, and we had many from, literally all over the country. It was nice to hear from someone who was able to say, and hey, since we're talking about it, you should know when we first, accounted for parenting time, oh boy, did we blow it. And here's how. And, and it's not to say that they were trying to give us a cautionary tale, but that's how we interpreted it and so I think, for me, and I'll let Johanna, who just raised her hand, chime in as one of the, another member of the group. It was just really nice to me to feel like we could learn from someone else's mistakes and not have to learn it the hard way ourselves. That was very appealing. So,
Did you switch over to mute? I missed the last sentence. Maybe me.
oh, sorry. I was saying, Johanna, I'll let you add in there. Maybe I probably hit mute on myself too fast.
Thank you, Katie. And what you just said is definitely a good part of why I think, and not everyone loved Minnesota. I was one of the people who liked Minnesota. Carol Walker, Dr. Venor is the woman who spoke up last time about Minnesota. What I liked about it, and I think I first learned of Minnesota from one of your reports many years ago that was written as sort of a in between, it was across credit, but not totally across credit, but it provided for very gradual adjustments early on. So to me, that read, higher support orders, at low levels of parenting time. And then, as we got closer to 50-50, it backed off, and that seemed to be fair in my opinion. And so that was the other piece of it. And the complicated nature of the formula, at least in the material that I've read, to legal aid organizations in Minnesota after the adoption of the formula, was that, yes, it's complicated, but it's going to be in the calculator. You don't even have to know what the formula is. And Oregon, the lookup table that they have as sort of that reference tool that I think if Georgia went with something like Minnesota, we could have a lookup table like Oregon's. And I started kind of piecing together something for the work that I do with my pro ses, to try to help them figure out what would be fair for a certain number of days that the non-custodial parent would have in terms of parenting time. So it just seemed like it was a fair perspective, and the cliff effect was something that a number of us were really concerned about, like Katie said, just making that mistake and then having to revisit this years later, because they went to income shares first, and then they felt that the cliff effect was problematic. But that's definitely a debated topic, the cliff effect. Thank you.
I do need to clarify that we can't convert the Minnesota formula to a lookup table like Oregon, so that it mathematically is impossible.
Okay. Basically, well, I don't want to waste anybody else's time with it, but even if you didn't go with something that's Minnesota, for example, if your cross credit formula that Colorado is using, if that has a gradual increase and it doesn't have a cliff, then I don't know that that's something that I personally, in my little opinion, would have a problem with. But I definitely liked the idea of small increments, because then you take away the argumentation for getting that extra overnight, and the amounts early on are so nominal that I don't know that many people would find an issue with that, or I could be wrong. But and then of course giving the judge the discretion to back out of the parenting time deviation, or adjustment. So if it's treated as an adjustment, the judge could back out of that if they determine that, the non-custodial parent's not providing any, sharing any of the expenses. So.
And I apologize, I jumped right to the little thing that I was critical of, because everything you said was really, I think, I appreciated hearing it, because, that study report is so thorough that, we read it and I get lost in some detail. So it's really nice. You did a wonderful summary. Thank you.
What, Dr. Venor, I'm kind of going through these supplements that you've sent us since our last meeting. What else can you sort of walk us through? Assume that even though everyone on this call is well-versed in these issues, that maybe we're not economists used to reading, memorandum like this. What else would you want to highlight for us in follow-up to our last meeting?
I really don't have that much. I think Carol made a really good point last time about, I had some definitions of alternatives for overnights, and that's an issue. And Carol said that it's in the study group's report. And so I think the lingering issues are, one is, what formula? I mean, if you can narrow down some formulas, I think what I'm hearing is there's a consensus that there shouldn't be a cliff effect in that formula. The trade-off with that would be that you would have a formula that could start at very low time sharing. If we have two parents that are almost equal income, and one has like 25% time sharing, it's going to kick in. If we have a situation where the lower parent, and this is both for any formula that doesn't have a cliff effect, if we have a situation where we have let's say we have the lesser time parent is also the lesser income parent. So let's say that we have somebody that's making about $10 an hour. So maybe about $2,000 a month or so. And then they only have 20% time with the child. And then the parent with 80% of the time has $4,000 in income. So that the Minnesota formula, the Oregon formula, the cross credit without a threshold might provide an adjustment in that case. So what we haven't talked about, and I remember it being in the study group's report, is whether you think that it would be fair for a flipping of which parent owes support when there's nearly equal income, or if the lesser time parent has significantly less income. And that will help direct which formula to use. So I think that's one issue, is narrowing down what formula. Another issue is the definition of overnights. I think Carol can speak of that. Maybe Carol or maybe Katie could speak about what you guys thought about that flipping. And then I also heard that the criteria should be, there has to be a time sharing court order. So I think those are the three really important things that I'm listening for. Actually, the last one is done. I'm mostly, where I come in is on the formula. And as far as your definition of overnights, you don't need me to do that. There's information.
And Jane,
in the memo.
I'm going to step in here for a minute. We definitely need your help with the defining the overnight.
Oh, okay.
Okay, we definitely need that help, because when we took this to the legislature in 2006, that was one of the things that everybody failed at. The legislature could not agree on defining an overnight. So we really have to get that solid and know how to explain it to the legislature when it comes time to do so that they are comfortable with what that looks like. So in my mind, we don't have that defined yet.
No, and Katie, one of the biggest issues with the study group is that there could not be a consensus on the definition of overnight. And so we were hoping that you would, I know you like for us to make the decisions, not you, but at least give us an opinion of which one seems to work best, and maybe what your recommendations would be for Georgia.
Yeah, I think let's put that in the parking lot. I'm okay with it. I think Elaine will brief me on what happened with the legislature. I think the more difficult is what formula you use. And when Georgia gets to the point where you decide that, then we also have to think about the language with that, and that we want the language to complement the formula on overnights.
Okay.
Well, and one of the other issues forgive me if I'm skipping ahead to something, but was when it was going to, when the threshold, I guess, was going to kick in. And with Minnesota, wasn't that one of the states where it kind of kicked in right away, like
Early.
early?
And it really depends on their income. I mean, when you think about it, if I'm going to use he for the paying parent, is if he's got triple the income, you know, he should be ordered to pay support up to, you know, even when there's equal custody. So the beauty of any of these formulas is that it really considers income, the income disparity of the parents.
But I think to Judge Williford's question, I think that the Minnesota being the prime example of the state that, you know, really went out of its way to fix its problem with the cliff effect. And, you know, to follow up what you said a few minutes ago, Dr. Venor, when you are, you know, when you are going out of your way to avoid a cliff effect, you are having a parenting time adjustment start earlier, even if smaller, at, you know, the increments are smaller, but it does start earlier. I mean, that's, you know, those two things sort of go hand in hand. That's one of the ways you avoid the cliff, is just to, you know, to draw out the line. I mean, isn't that a fair summary?
Yeah, and that's the way you avoid the cliff effect, and it's probably the most difficult thing to explain to the legislature, because they're convinced, and I'm not talking Georgia, I'm talking in almost every state I've worked with, is that if you have a parenting time adjustment that starts at 1 overnight, that, you know, that's not fair to the receiving parent. But what it is, how you present it, it's like, well, we also consider the income disparity between the parents in the formula.
Well,
So,
and I think it's fair to say, or like, I mean, in my opinion, having sat through the study committee, is that I think we heard from lots of people from varying backgrounds and professional experiences and personal experiences, that there's concern about incentivizing litigious parents to litigate for parenting time for monetary purposes, as opposed to with a focus on the best interest of the children. And, you know, I think that's a concern. I'm not saying people do or don't. Well, I do think people do that. I think it's a valid concern, but we heard it in the study group. We heard concern that we also don't want to incentivize that. You know, on the other hand, you don't want to disincentivize parents to spend time with their children because they can't afford it. So, you know, talk about, you know, the world's worst catch-22, you know, or because they feel like they have to be at work because of their financial obligations. You know, it's no win, but we did hear concerns about, you know, specifically about the, you know, creating a, you know, litigation scenario for parenting time that is not rooted in it. Well, that is, let me just say it this way, that is rooted in finances as opposed to other good intentions.
and that's why I think I'm hearing from the group that you're putting guardrails on it by requiring that there be a parenting time order.
Right. I think that is one of the reasons for requiring order. Johanna, did you have something to add?
Yes, Katie, thanks. I will just say for reference, before Minnesota adopted the new model, it was less than 10%. There was no adjustment, not less than 10% of parenting time. Anything over 10%, 10 to 45% was given a 12% reduction. And then 45.1 to 50%, the equal parenting time formula kicked in. So it was pretty low to begin with, and they still had issues with that. And one of the things that I got in talking to some of the Minnesota practitioners was that even for the low income folks, the perception was that their model was fair. And there was a belief that because people perceived it to be fair, they were more likely to abide by the terms of the order. So those are the only other comments I wanted to make on that. Thank you.
Johanna, will you say that again? 0 to 10% parenting time. There was no adjustment. 10 to, or I guess anything over 10 up to 45 was a 12% adjustment. And then what happened at 45?
there was an equal parenting time formula that kicked in, and I don't honestly know or remember the details of that. But that's what it was, 45.1. So it did something different that gave a more dramatic reduction. And Dr. Benor, if that doesn't sound right, then please correct me.
No, you're right. That's the way it was structured. And what it did was it used a cross credit at about 45% time. So once you get to 45%, there was a sudden decrease, And so they were worried that there was a lot of bargaining to get right at that 45-ish % time.
And which state was that again?
Minnesota.
Minnesota.
And they changed their formula. Gosh, I want to say it was like 2017, 2018.
It was 2016 they adopted, or they agreed to it, and then 2018 is when it went into effect.
And they say it doesn't, go ahead, sorry.
The 10 to 45%, that's a huge range. But it stays at 12% regardless of whether you only had 11% or whether you had 45%. Does that not strike anyone as strange or unfair?
There was a legislator that developed that, and at the time, Minnesota was going, not only like Georgia, they had a percentage of obligatory income guidelines, and they were going to income shares. And he wanted to push through a time sharing adjustment and a low income adjustment. So you can imagine, not only is he doing income shares, but a low income adjustment and time sharing. And that was where he could get the most compromise. And for you all that went through Georgia's switch to income shares, how controversial any guidelines change can be.
Dr. Benor, can I ask a question? Is that all right to the panel? Okay, when you said Colorado is doing a cross credit, I assume that there is is it a linear or gradual like Minnesota, just a different formula that gets you to that place? And I have looked at it, and I'm just curious, beyond that then, because they're talking about doing a threshold of what I think you said 92 days, does the graph just look like there's just nothing, and then all of a sudden at 92 we have sort of a gradual increase or decrease in support obligations?
If you look at page 7 of the memo, there's a cross credit with different multipliers. And I have it set at a 25% threshold. So what happens, and this is an example where we have equal income, if we had no threshold, then that line, cross credit at 1.5 is what most states do, would just kind of keep going to those lower level of timeshares. There'd be more of a slope.
Okay.
It wouldn't just get a cliff there, and it would vary. So I think it would be close to like 16 or 17% that you would start to see an adjustment. Now with, we had an example where the income was, the obligated parent's income was 8,000. Then it might start being gradual, more like at 25% or something, or 21%. So where it starts to get that slope will depend on the relative incomes or the income disparity between the parents. It's hard to visualize. I'm not sure if I'm giving you a visual picture with words.
I have a question. I think I understand what you're saying, Dr. Benor, but just not exactly changing the subject, but switching the focus on this cross credit concept really quickly. Did I understand you correctly? Not today, but at I think our last meeting, to say that I see the multiplier is 1.5. You also did it with 1.4, just so we could see, but that really the economic support something more like 1.6 or 1.7.
Got a good memory.
So, okay, thank you. So why put a discount in the cross credit does that circle back to your point a few minutes ago that, you know, at the end, we're dealing with the legislature and we got to give them something that they can swallow? Or because that sort of bothers me. If the economic support one thing, why do we put that to the side for certain things and not for others? I don't know, that bothers me.
You know, the cross credit was recommended back in 1987, or it was actually earlier, 86. It was by the National Child Support Advisory Group. It was formed by the Federal Office of Child Support. And Colorado was the first one to adopt it. And at that time, it was in the 1980s, they looked at housing and transportation were duplicated expenses, and it was about 50%. Since then, housing has taken up a bigger share. So when I say 60 to 70%, I'm giving you the most recent economic data, but states are remembering, you know, that what was recommended in that guidelines report. And, you know,
87?
one state, yeah, 87. And also, I'm not sure
Well,
when it
just out
really
of curiosity, I'm not arguing with you in this, but I'm just going to say, I was in the second grade in 87. And I've now been practicing family law for coming up on 20 years. So I'm not sure who's remembering the 87 report, but I have to imagine some of those people have retired. I don't know. Because I'm coming up on 20 years, and you know, the 87 report, I guess in theory could have affected me because I had divorced parents, but not because I understood, you know, which end was up.
To be honest, Illinois asked me to look at it maybe 2 years ago. So I think they were the first state to revisit it.
Okay.
You know, so most of those states that are using 50% adopted it in the 90s.
Okay.
And then, you know, Illinois was the first state that said, you know, this just doesn't feel right with what we're seeing. And so I started looking at the numbers again, and that's when I was like, you know, you're right. It should probably be 60 to 70%.
Okay. Yeah. I guess I will say it's going to take a lot of convincing for me to get on board with the idea that we ignore current economic data for bits and pieces, because it might be more palpable. Not to say that I don't understand that sometimes that's what you do to get a law to pass. I don't, you know, that's where you start to think about how the sausage is made. And that's why we've got people like, you know, Mr. Estration and Mr. Strickland, you know, sitting in on these committees, because they, you know, they then go help with the sausage making. But you know, if we're going to be looking at that, I would hope that we would be looking at the most current data, especially if, you know, and using the most current economic information available, especially if we're going to be making a change. I don't know. If we're stepping forward, let's step forward all the way. Don't step forward to the 90s in 2023. You know, let's don't go to where we should have been when I was in the second grade, when I'm in my, you know, 19th year of practice, I guess is what I'm going to say. So I would appreciate it if, you know, if as we're discussing this, we consider, you know, not a watered down multiplier, because that might make people feel better, but real numbers. That's just my opinion.
Can I ask a follow-up on the multiplier question? So does the 1.5 or 1.6, whatever you use, how does that affect the ultimate child support amount versus a linear, or, I mean, something like Minnesota? I mean, is it going to actually reduce the support payments because you're increasing the overall cost of raising children to accommodate two households? I mean, what's the ultimate effect of using that multiplier?
The higher the multiplier, the higher the order amount. So, and I'm a little bit confused because
yeah, it's not I don't really think I understand it completely myself, but when I see that cross credit with the 1.5, my understanding is it's like we're saying that it's 1.5 households, or am I totally wrong about that, how I'm perceiving that? I mean, that basically we're trying to accommodate the fact that both the custodial parent and the non-custodial parent have rent or mortgage or whatever. And so the total overall costs are higher. So instead of, okay, so Georgia does not have that. We're talking about increasing the overall costs. What I'm not sure of is when it all shakes down and you do the calculation and the cross credit, is it going to result in lower support orders versus using the exponential formula, or is that not a question that can really be answered the way I'm asking it?
I think you asked a really good question. Like there's some that argue that, like, look, we just take that basic obligation, and you saw it in somebody saying, and we just divide it by the number of days. And that's if if it's a $365 in orders, that's $1 a day, just to keep the math simple. So we get $1 credit for 10 days would give us $10. And what the multiplier does, it says, it's not 365. It's, it would be 1.5 times that. So, close to $600. And then we do the adjustment because, the primary parent still has those housing costs and they can't just rent out the room. It's not like, you all know this from you buy food at Costco and your kid goes away for the weekend and, it's not like you bought like a pint of milk and really saved a lot of money. So the multiplier, I think, is really important to recognize that it costs more to raise a child in 2 households. And what that does is that parent isn't going to get $1 a day credit. If we're assuming that 365, they might get 50 cents instead of $1. So the higher the multiplier, it might be 25 cents rather than 50 cents, but it's still pretty gradual.
So the answer is no, it's not going to reduce the support amounts.
It will, but not as much as a per diem.
Okay, gotcha.
Right. But it's not that it's, I don't know, I maybe I'm thinking of this incorrectly, and God knows I'm not an economist, but I am dangerous because I do have 2 accounting degrees. So I do have like a numbers background. It's all, but it's like complaining to me. It's like complaining, I live in Metro Atlanta. I mostly, not exclusively, but mostly handle divorces in Metro Atlanta. The child support, the basic child support obligation table, very often for my clients feels insufficient for what it costs to raise a child when but this is because they're coming from Metro Atlanta perspective, but the basic child support obligation, as we, hopefully everybody on this call knows, and certainly Dr. Benor knows, that was created using, a cross section of counties all over Georgia. And every time we do an economic study, we look at a different, slightly different sampling, obviously always with some metro counties in it, but also with some rural counties. It can't be perfect. No economist is going to sit there with a straight face and say that the cost of living in, Ocilla, Georgia is the same as, the heart of Atlanta. But, you take all of the information inside of the state boundaries and you deal with it. And to me, that's a similar thing as to saying, it's impossible to know exactly dollar for dollar how much more it costs to raise children in 2 households, but we know it costs more. And the current economic data, the good data that we have right now is that it's more like 1.7 than, what it was in my childhood at 1.5. And does that mean that somebody's going to pay a little more or a little less than they might otherwise? I think that's what happens when you're developing a system for the state, and for, when just like it happens that the BCSO number for someone in Ocilla is going to, have a different impression than for somebody in downtown Atlanta. Is that a bad analogy? Am I looking at that wrong? But isn't that kind of how it goes sometimes?
You've got a lot in there, Katie. Thank you. A lot of concepts and thoughts. And I think, you're on the right track. I think, these are guidelines, they're rebuttable, presumptive, and it's important for judges. And that's one of the reasons you guys have Georgia's very aggressive in their training of judges to help them understand what the economic assumptions are. And I think that's great because you want judges to deviate when it's appropriate for the circumstances of that case. You are required federally to have one statewide guidelines. So, and you're right that there's economic disparities throughout any state. There is economic evidence that there is some self-correction by incomes, that incomes are generally higher the housing costs are, and housing is the one thing that drives it. So, I agree with almost everything you say. And I didn't hear anything. I just wanted to make sure that you all understood that you have to have a statewide guidelines. I mean, that's a federal requirement. And to honor, you know, that you do have a very good training unit. And, you know, the judges are trained to deviate when appropriate. And I think everybody takes that very serious from what I've heard in Georgia. I will say, we've been talking about the multiplier for the cross credit, which is a different formula than the Minnesota. And on
Right.
page 15 of this memo, Michigan and Minnesota actually use the same formula. And instead of using a multiplier, the difference between Minnesota and Michigan is that exponent. And Minnesota uses 3 and Michigan uses 2. And you can kind of view it as the higher the number, you know, the more consideration there is for how much duplicated expenses there are. And what I wish I had on here is a comparison of not only Minnesota, Michigan, but also a cross credit with like a 1.5 versus a 1.6 or 1.7, and a bunch of different examples, because these are parents that have equal income. If I'm hearing you all right, and I'm going to pause here because I want to make sure I'm hearing you're kind of interested in the cross credit, you're kind of interested in Minnesota and Michigan, and I think you need more comparisons to see where those adjustments would kick in, and I think you need some dollar amounts.
I will say you're hearing me right on that. I don't want to speak for the whole subcommittee, but you're hearing me right on that. I don't know why, especially after having, you know, chaired the study committee. I'm not sure why it resonated so resoundingly with me so recently, but it really bothers me that we have economic data establishing that it costs so much more. I mean, it makes sense to me, but that we have economic data establishing how much more it is to raise children in 2 households, and that we're not actively working to account for that. That just, I think that's to me, that's a failure in our system. That, not that we can make a perfect system, I don't believe we can, but I think we have a duty to really explore that.
I have a question for Dr. Venora.
Go ahead.
So we've talked a lot about the multiplier being the 1.5 multiplier. On one of your memos, you mentioned there were 4 states that had a cross credit with no or alternative multiplier. How does that work, and how does that compare to the 1.5?
Good question. Thanks, Christina. Thank you. You're a good student. You read it. So I think there's a graph. I'm trying to flip through the page here that shows that. And it's page 7. And that's an example, you know, there's a cliff effect there because we have a 25% time sharing. So nobody in that example, so nobody's getting an adjustment until it hits 25%. And you can see that if you use no multiplier, which, you know, some people argue, given again that 365, if the order amount or it was $365 a year, then it would be $1 a day for child. They say that that's exactly transferable. If the child's no longer with mom, dad picks up that $1. So that would be the lowest line on that, and that's no multiplier. Virginia uses 1.4, and you can see that's the second lowest line. And then 1.5 is the most common, except for West Virginia is now going to start using 1.6 beginning July 1. And I worked with West Virginia, and they went with the 1.6 for exactly the reasons that Katie was discussing. And then you'll see that Oklahoma did something. This was a policy thing, and it's the highest line. And they start off with a lower multiplier and then gets bigger. And they did that mathematically to soften the cliff effect. But my thing that I'm realizing working from Colorado is just get rid of that time sharing threshold and let it vary. And it's going to vary depending on their income disparity. So did I answer your question, Christina?
I think so. I think my follow-up question would be, so then the no multiplier, is that similar to the per diem? Is it having sort of the same outcome effect as that? Okay. Gotcha. And I think if I remember from the last meeting, I think you were sort of, your favor was more towards using a multiplier, a 1.5 or higher, like we've been talking about what Katie mentioned. Okay. I think too,
Go ahead,
I
Christine.
think I was going to say what you said prior to that was about giving us some more examples with actual data. I think that would be great. I think that would be very helpful. I know for myself it would.
Yeah,
And
that's
for
what
the rest of the committee. Yeah.
Yes, no, I want to reiterate with Christina. I think some additional examples, yeah, I would love to see some additional examples. Here's what would happen in this scenario. Let's take scenario A, scenario B, let's look at it. And frankly, it goes to, she had to jump off, but it goes to even Johanna's sort of bigger question. Can you tell us, is it going to make overall, will it make, orders go up or down? I think people, even though I hope that's not the kind of thing that drives what we do, because it shouldn't be, but I do know that people are curious about that. And I have to imagine that will be the kind of question we will have to answer with the legislature no matter what. So I think some, varying examples would be helpful. Do
you have any incomes and time sharing arrangements that you see a lot of?
I would be more than happy to put together some, a couple of bullets, of like situation A, situation B. I mean, I'd like to sit down with it. I don't want to give them to you in the middle of this meeting, but yeah, I'd be happy to put some together and email them to you. And if anybody wants to contribute, I know Christina's helps people settle their cases every day. So I know she gets to see, from a different angle than I get to as the mediator. But yeah, I think between us and, Judge Williford certainly is making those decisions, and Mara's exposure is a little different. I don't know. We could definitely put together some, could you give us, some of these and some of these, yes, I think we could do that. Don't y'all agree we could put something like that together?
Elaine would love to coordinate it.
Well, this is why I popped back in. So we need to know, because this meeting is a month away, the next meeting in June, we need to know how quickly, Jane, do they need to get that information to you so that you can prep for it?
When's the next meeting in June?
Oh, hold on. I have my little, here we go. I have my chart. It is going to be June 23rd, Friday, 10 a.m. statute review. I know that's early for you, Jane. Time difference.
I think like 10 to 14 days in advance of that. So maybe like June 10th or 11th.
Okay. So can we, I don't know what day of the week that is. Let me look at my calendar. June 10th is a Saturday. So could we have all of y'all's responses by June 8th, Thursday, June 8th? That way, for sure, by that Friday the 9th, we can send them, because we have a holiday. I mean, not a holiday, but a weekend in there. Does that sound plausible? Or even earlier?
It does to me, and I'll just throw in there, just for those who are, to whom it applies, the Family Law Institute will have just taken place. So for anybody who is attending and wants to weigh in on that, why don't you ping me? And because Judge Williford and I are going to be there for sure. And maybe we take a few minutes and meet before or after one of the sessions and just cross notes. But yes, Elaine, to your question, the getting something to you by the 8th sounds perfectly doable.
All right, that's an action item.
Okay. Elaine, I'll share with the whole group that your name came up in my office yesterday, and they were bragging about how you are the best and nicest at herding cats without, and always so gracious about it. And you do it with such kindness and patience. And so we just, so that's what you were doing right there, jumping in. So thank you for that.
You're welcome. I learned to herd cats when I was a little girl.
Well, it shows your years of practice. Now you're hurting lawyers, which I don't know, might be worse, and judges and everybody else. Is it okay with everybody if I shift us just a little bit in this conversation before we run out of time with Dr. Benor? Anybody have an objection? Anybody have anything to follow up on what we've been discussing? Okay. So Dr. Benor, a couple of times maybe not yet today, but definitely in our last meeting and definitely in many before that, we've gotten inquiries from members of the public, interested parties, people who sort of follow what Georgia and other states are doing with respect to child support and parenting time. And I might butcher this a little bit, but there seems to be sort of a similar line of questions about child support changing over the course of a calendar year based on the parenting schedule. Specifically, it comes up with summer where, for example, the parent who's during the school year, maybe, noticeably is the sort of secondary parent. I know nobody likes those labels. I apologize in advance for the labels. I'm sorry. I'm, bound by language like everyone else. But, it's not uncommon to see a schedule where the sort of primary or majority time parent or whatever horrible phrase we want to use switches in the summertime. And yet our guidelines and our statute in Georgia don't make any any changes for summer child support. And we get asked about that. And I'm just wondering if, and I'm sorry to this was really kind of unfair. You didn't have any advance warning about even this topic. But I'm wondering if in all of your years and work with all the many states, have you ever seen a state that, had a child support order for 10 months of the year and a different one for 2? Or, my typical and logical response when I get questions like that, at least in my own head, is, well, we've accounted for that because we do everything based on a 12-month average. But then I've thought to myself recently, maybe that's not an unfair response, or maybe that's not a fair response. And so I'm wondering if you can speak to that at all. If you ever hear that issue, if you've seen any other states make adjustments for it, anything like that.
You're absolutely right, Katie, that the precedent in most states is to average over that. So if they're there for the whole summer, that's like a quarter of the time. And so the monthly amount would be, different to account for that. There are some states, usually it's called a, suddenly I'm blanking on the word, where they pay the other parent. I had it because you were describing it and I just forgot what that was called. A lot of states have eliminated it. It's oh gosh, I'm just Wyoming used to do it that way where it would flip. They would have one parent, they could get they'd have to go to the clerk of the court and they'd get the order for 3 months. So, let's say the kid was there for 10 months. 3 months in the summer, they would get a offset. They would get a refund for that. The clerks of the courts hated it. You can imagine the bookkeeping issues with it. And there's a few states that still do it. I'm pretty sure Kansas still does it and South Dakota does it. And they, but these are smaller states. You have a lot more volume. And, and the states that South Dakota, they're pretty attached to it, to do it that way, the way you initially described it. But South Dakota is a very, very small state.
Right. They have incredibly small population is my general understanding. Big geography, small population.
So most states have abandoned that approach and gone with just averaging it.
It seems to me, Katie, if I might pipe in, that if we will fix the parenting time problem, and I call it a problem because right now we don't have one. We have this deviation, which is very rarely used. And if it is used, it's used in a joint custody situation or something close to it. But if we fix that, then we can account for, the summer times, the holidays, the weekends, everything else, because if we look at a 12-month period, if this language, the non-custodial parent has the child for 8 weeks in the summer and, spring break and a week at Christmas and every other weekend and blah, 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 we can figure out, okay, that equals, 100 days or whatever. And then what would that mean for the parenting time adjustment? But I'm with you. I've been asked that question a million times over the years. And I've always said, yes, that's accounted for. But now I realize that it was not accounted for because the worksheets as they are currently, do not give a parenting time adjustment. They don't have anything built in or anything like that for parenting time. So I think that's part of clearly the key reason we're trying to fix this. And I think that will make folks feel a lot better when they realize that, yes, you are getting credit, because if you weren't getting credit, you would be paying more every single month, but you're getting credit. It's just that credit essentially is being divided by 12. And so you're getting a monthly credit instead of a July credit or an August credit, sort of like paying your Georgia Power bill based on your history, where every month your Georgia Power bill is $200 instead of in the summer months it's $300, but in the winter months it's $100, and if we fix the problem, we can explain it to folks that way.
Right. I agree with you, Judge Williford, and I think the flip side of the argument is when the custodial parent or whichever parent is paying for summer childcare, and their budget changes in the summer, and they say, how come I'm not getting more? And the answer is, well, when we calculated your child support, we accounted for the fact that child support costs more or child care costs more in the summer. It's just that we averaged it out. So then it a little bit becomes incumbent on you to budget accordingly. I don't get paid more in December just because I'm buying Christmas presents, but easy to say, budgeting's hard. And it certainly can feel, like the situation is flipped. But I agree with you. If the parenting time were addressed in a way that felt more fair and reasonable, that would address some of that, feeling that the summer parenting schedules are not, or summer child support is not fair. So I agree with you, but I also think that we get that question so often. So I just didn't know. But I'm glad to know, Dr. Venora, that there is at least one state we can look at that does do literally a different amount in the summer. I will say, I don't know if we've lost any of all of our D4 folks here, but I can't imagine what a logistical and administrative nightmare it would be for income deduction orders and other support orders to have, a month or two out of the year. I mean, we already have incredible challenges for those families for dealing with preschool age children, and having that additional preschool cost in there. But we get asked, and so I just wanted to see what you could tell us. So you answered it. I appreciate that. We'll look into it. We're pushing up on our time here with Dr. Venor. Do we have anything else that we want from
Well, I was going to say it's 3:59 p.m. now. We have our next meeting on Friday, June 23rd. We'll try to get those examples to Elaine by Thursday, June the 8th, so that she can get those to Dr. Venor and we can pick up there on June the 23rd. LaTonna, are you still with us?
Sorry. Yes, I am.
Do you have a quick 30-second update on the survey results?
Yes, let me share my screen to show you guys.
Did you update the table that you had prepared, the graphic rather?
I did for
Cool.
this upcoming,
Well, while she's pulling that up, I want to mention, and Erica's still on the call with us for 4D, and Noelle and LaTonna and I both know, or all three know this. So many of the people that are answering the survey think that we are the Division of Child Support Services. They do not know how to distinguish the Child Support Commission from DCSS. So Erica, I'll share this stuff with you at some point, but they fuss in several of the comment locations instead of giving us new title ideas for custodial or non-custodial. They tell us using profanity sometimes what they think about DCSS, or that you should lock everybody up or you should let everybody go. I mean, there are a lot of opinions in there, and it's been interesting reading some of that information. And I really had hoped that we wouldn't see that, but we are getting good responses. But LaTonna has a new chart for you.
All right, LaTonna, tell us about your chart.
Okay, yes, and everyone can see the chart?
Yes.
Yeah.
Okay, Awesome. All right. So this is the latest results from, I believe, up to May 15th of the responses that received from keeping your custodial parent, non-custodial parent, or changing the terms. As we see, this one has always been the forerunner, the keeping the terms the same. This is custodial, non-custodial parent. We have 851 kind of voted for that. And it just kind of jumps back down to, like, for the orange, it's 81 for if we want to change it to greater time parent, lesser time parent. We have 65 for obligee, obligor. We have 111 for payee, payor. 261 for primary parent, secondary parent. 118 for receiver or payor. And then we just have the 251, as Elaine was stating, just people that are in their own suggestions, which are different things. But again, just the big one that has not changed is honestly just keeping the terms the same as custodial, non-custodial parent.
That's
That is
interesting. That's overwhelming. And then the next one,
the primary.
which is one I used when I was practicing a lot, was primary and secondary. So, so that's interesting. Well, we have gone over, it looks like. So, if there's no further business, then I guess we will conclude the meeting and reconvene on Friday, June the 23rd at 10 a.m. Elaine, anything?
That's it. We just appreciate everyone's attendance, and please have a safe and wonderful little holiday weekend. You get 2 days off.
Right.
Katie,
And
anything from you?
yeah, I was just gonna say, I'm sorry to Pat and I guess any of the other, I know we did have some additional agenda items, and I guess we're just trying to capitalize on our time while we have Dr. Venor, and gonna take advantage of knowing that that some of our committee members who have no less important things to discuss, but we get them more often than we get Dr. Venor. So we'll
Keep pushing those to the next
yeah,
agenda so
we'll
that
just
we don't lose
keep
track
rolling
of
the
them.
agenda items. So so thanks
Yeah.
everybody. If for those who have a burning scenario that they want to see Dr. Venor do, if you'll ping me, I'll make sure it's on our list, and Judge Williford and I'll be sure to go over it when we're together at the Family Law Institute.
Perfect. Thank y'all. Have a good weekend.
Thanks, everybody.
Thank you.
Thank you.